in the name of personal injury law.
The Michigan Court of Appeals recently issued a very significant decision regarding Michigan's auto no-fault law. Today we have with us personal injury attorney Steve Sinus of the Sinus Ramos Law Firm and his colleague Lauren Kizel. Now they both worked on this case along with the rest of the firm, and they're going to tell the viewers what this case is all about and how it impacts us.
Thanks for having us. Before we get to the case, I just want to start with an explanation about what happened to the Michigan no-fault law in 2019. The legislature added very significant amendments to how the law works for catastrophically injured people. Prior to the amendments, the original no-fault law said that people catastrophically injured in motor vehicle accidents were entitled to have lifetime care for their injuries under the no-fault system, and that the no-fault insurers would have to pay a reasonable charge for that care. So these people could go to their medical providers and say, I need this service, I need this accommodation, and turn to the no-fault insurer, and the no-fault insurer would have to pay a reasonable charge for that service or accommodation. They could also have their family members be paid for providing them care that they needed in the home, and there weren't limitations on how that benefit was handled. So what was going on in the system is that thousands of people were catastrophically injured in motor vehicle accidents. They were relying on these rights they had under the original law. And then in 2019, when the legislature changed the law, the issue became whether or not those changes would apply to those people who were injured prior to those changes being passed by the legislature, and those people who are relying on the original no-fault law, were their rights now changed as a result of the 2019 amendments. And that is the main issue that was in play in our case, and it's known as the retroactivity issue, whether these new care limitations that were passed in 2019 could be retroactively applied to these catastrophically injured people. And so the case that we handled is known as the Andary case. There were three plaintiffs that we represented, and continue to represent, the Andary family, the Kruger family, and a medical provider known as the Eisenhower Center. And the argument in the case is essentially that it's unlawful for these new rules to be applied to our clients because they had their rights under an insurance policy that was sold to them under the original no-fault law. They had been relying on those rights, and that now by imposing the new limitations on their care, such as how much their medical providers get paid, which is a new feature of the law, it's really jeopardizing their ability to access the care that they need. And so we've been arguing in this case that these new limitations on the rate of reimbursement and how family members who provide our clients care, how those new rules apply to people under the amendments do not apply to our clients, and it would be unlawful to do so. And so we filed a case in the Ingham County Circuit Court, and that's where this litigation began.
So Lauren, what happened in the trial court?
Unfortunately, we lost in the trial court, and the trial court judge held that these amendments could be retroactively applied to individuals who were injured and purchased their policies prior to when the amendments were enacted. But it is important to note that this decision was rendered before a very important case by the Supreme Court was issued. Very important opinion in the Buell case was rendered in 2021, which is a very important retroactivity decision that we are basing a lot of our Andary arguments on.
So does this trial court decision in your case affect other people around the state?
Well, that's what's so unfortunate about what's going on with the chaos that's in the courts over this issue. It was a good thing that the loss that we had in the trial court wasn't applicable to other people injured throughout the state. But what we had was a tremendous state of uncertainty about what the law was. And actually, several circuit courts ruled in such a way where they basically agreed with the arguments we're making in our case, which is that these new rules can't be applied to people injured prior to the effective date of the amendments. So there was no precedential binding effect of our ruling on other people's cases. Meanwhile, other courts were deciding the issue differently, which is why our case at the Court of Appeals became so important to bring more certainty to the law.
So how was the case handled in the Court of Appeals?
So we tried to expedite the case, given that the fee schedules and several of the key things that we were arguing in the case were being implemented in July of 2021. Unfortunately, the Court of Appeals denied our request to expedite, so it proceeded in the ordinary course. The case finally had oral argument on June 7th of 2022 this year before Judges Douglas Shapiro, Jane Markey, and Seema Patel. And again, we focus on the retroactivity issues, arguing that these amendments could not be retroactively applied to individuals who were injured prior to the amendments being enacted.
So what did the Court of Appeals decide?
Ultimately, the Court of Appeals agreed with our arguments and held that there was no indication of intent by the legislature in the amendments to apply these changes retroactively, and even if there was, that would violate the Contracts Clause of the Michigan Constitution.
So let's talk about the significance of the Court of Appeals decision.
So this is a published decision. It means that it is binding on all other trial court cases, which means that other trial court judges do have to follow it for the time being.
So it brings consistency around the state, right?
Correct.
Okay.
In theory, it does. And we can now go into court telling trial court judges, you have to follow the law. Unfortunately, the insurers don't want to abide by the decision, it appears, or at least some don't. And so they're asking trial court judges to stay cases, which is like hitting the pause button on a case, while they try to convince the Michigan Supreme Court to overturn what the Court of Appeals held in our case.
Okay, so what's going to happen in the Michigan Supreme Court?
Well, the insurance companies have filed an application for leave, and the way it works is you have to ask the court to take your case. The court doesn't have to take your case. So we're now in this phase where they're requesting that the court hear the case. We think that even if the Supreme Court happens to agree with the Court of Appeals, they may take the case just because it's such an important issue. So we're now kind of in this waiting game where the Supreme Court has to decide whether it takes the case. And if it takes the case, then it has to hear the case, which, as you know, can take quite some time.
So something I think a little unusual has happened in this case in the Michigan Supreme Court. In my experience as an appellate attorney, the insurance industry has filed what I guess they're calling a motion to stay the precedential effect of the Court of Appeals published opinion. Can you talk to us a little bit about what they're trying to accomplish with that motion?
Basically, the insurance company is trying to get the Court of Appeals and Dairy decision to not have any precedential value. So essentially that would go back to before the Court of Appeals decision was issued, and trial court judges can decide the case however they want. They don't have to follow the Dairy decision.
While the case is still pending in the Michigan Supreme Court, which is really the opposite of what normally happens, isn't that right?
Right.
Yes.
So does that, what happens to all the catastrophically injured people around the state who have basically been living in limbo for the past year or so?
More limbo.
More limbo.
Unfortunately, because the insurance companies don't want to abide by what a published decision says from the Court of Appeals. And I just want to bring the viewers back to the issue at hand, and it's whether or not these people can access the rights they've always had under the insurance policy that they bought from their own insurance company. And what the insurers are arguing is that they have to take away these rights in order to bring down everyone's insurance rates going forward. And that's really what they're putting in these briefs. So when the public thinks about this case, they should think about, is it fair for people to have the rights that they bargained for taken away in the name of trying to lower rates going forward? And one thing the Court of Appeals talked about is that there was no real proof that taking away these people's original rights was necessary to bring down rates. So there's a real issue of fairness at hand here. And unfortunately, in the meantime, not only the insurers not abiding by what's fair, they're also asking the Supreme Court to put a pause button on trial courts applying the law as decided by the Court of Appeals.
So, I mean, not just your clients like the Dairy family, but there's a lot of families that have been actively harmed by the decisions that have been rendered regarding the insurance companies' handling of these cases, right?
Yeah, this decision affects thousands of claimants across the state, so it's a very important decision for sure.
Well, thank you for sharing your time with us.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinus Dramus Law Firm.